So, Emer, I've been hearing an awful lot about this new legislation we're going to have, the Commercial Rents Arbitration Scheme.
That's right. The snappily titled Commercial Rents Coronavirus Bill has been released alongside a code of practice and an entirely non-illuminating explanatory memorandum.
So, who's going to be in and who's going to be out of the new scheme?
Really, really important, really interesting questions come out of that. So any business tenancy with protected rent debt, as defined in the bill, will fall within the scheme. But I think what's most interesting is that which falls without. There's a kind of in-between category, which is the cases that are rumbling on at the minute. There are, if the landlord, or it's usually a landlord suing a tenant for rent, and that claim is still sort of in the process of being determined, in the period from the 10th of November until this Act comes into force, the Act is going to provide that either party can apply for a stay so that the claim can go into arbitration. And I think you have said that you've had some indications that judges are likely to, even before the legislation has been passed, are likely to accede to those stays, those requests for stays.
I think that's right. I think the sort of general tone is that the judges can see the legislation coming around the corner. So if it's a claim which is going to be caught by the scheme, I think they'd probably accede to a stay application in any event.
Yeah. And then there's the provisions for anyone who's got a judgment on protected rent debt between the 10th of November and whenever the legislation comes into force. And that judgment becomes close to worthless because the tenant can still make a request for the protected rent debt to be dealt with in arbitration, and the landlord can't enforce. Really interesting.
But so who falls outside? If the landlord already has a judgment in their favour before the 10th of November, then they're not within the scheme, are they?
No, I believe not. And similarly, if the tenant has already paid, then they also fall outside the scheme. There's no debt to be arbitrated on in that scenario. And also, if the parties enter into an agreement, so at any point, actually before the 10th of November, after, if you enter into an agreement, then you're stuck with it. And so anyone who's regretting bad bargains that have been made are unfortunately going to be stuck with those.
Right, okay. So it's going to be really important, isn't it, as to who makes a proposal and how it's made and that sort of thing. So there's going to be some game playing there.
Definitely some game playing. So the legislation provides this process where it mandates that before the arbitration starts, 14 days before, whoever wants to start it needs to send a notice to the other side. And the code of practice says that with that notice should come a proposal. And then there's a 14-day response time, and then the reference to arbitration can then be made. And that is going to be, I think, a really interesting pressure point for the parties, because there's really some interesting questions about who's making the decisions here, who the arbitrators are going to be.
Yeah, so it's not necessarily or perhaps not ever going to be a lawyer arbitrator, is it?
There's no requirement that it's a lawyer. There's certainly no indications in the code of practice that they expect it to be lawyers. They want people with business acumen and business experience. They need to be independent, they have to be impartial, all those sorts of things, but there's nowhere in any of those documents any indication that they need to be legally trained or have any legal training.
And that makes sense in the sense that most of the questions that the arbitrator is going to be resolving are about the viability or solvency of a party, so you would expect them to have business experience. But interestingly, what struck me is that the kinds of disputes which can be covered by the arbitration scheme also include legal questions like, is there actually a protected rent debt at all?
Yeah, and that's going to involve quite a lot of potentially difficult legal questions. Tenants trying to rely on the kinds of arguments they have done in the High Court cases, saying, well, there's no rent debt here. Or alternatively, there's also going to be questions arising out of the legislation itself, because when it comes to be construed, I'm sure there'll be all these little problems in individual cases, and the people making the decisions won't be lawyers.
Yeah. And although most of the disputes, I think it's anticipated, will be determined without a hearing on paper, there is a provision, isn't there, which entitles either party to ask for an oral hearing.
Not just an oral hearing, an oral hearing in public. Yes. Which is just, I mean, it's the strangest kind of arbitration in the world. It's not by consent and it's in public. So that's a really interesting measure, and I think you thought that was probably to comply with Article 6. That's right.
I think it must be. I think there must be concerns that otherwise the legislation wouldn't be compliant with the Human Rights Act and the Convention. But there's a huge tension, and it seems to me plenty of opportunity for game playing again, because there's going to be a lot of confidential information out there, either from the landlord or from the tenant, possibly both. It probably means that one or other party isn't going to be keen on that laundry being laundered in public, which gives a huge amount of leverage to the party who does apply for an oral hearing, knowing that it's all going to be out there.
Yeah. It seems like such a strange provision in the legislation, because there is provision there in the bill for the arbitrator to have to extract from the public judgment any confidential information, but there's no provisions excluding the public from the bits of the hearing where there's confidential information. If the parties agree, they can have a private hearing. But this, your point about the leverage, obviously, if it's beneficial to one party to not agree, then that's exactly what they'll do.
And there are provisions, aren't there, which say that any manipulation by either landlord or tenant of their financial circumstances with a view to getting around this arbitration scheme or its results are to be ignored. How's that going to be tested?
I don't know. I mean, to me, that seems like a classic cross-examination point, because it's essentially a question of intention. You're asking, well, you've made this restructure, you've moved all these assets out of your balance sheet. Why did you do it? And do I believe what you're saying? Did you do it with a view to changing your position in this arbitration? And then it comes back to the point about, isn't it strange that the people making these decisions won't have any training in making those kinds of factual decisions? Is somebody lying or not? And
they're being told as well that when they have an oral hearing, it's to be inquisitorial rather than adversarial. So you've got what is ultimately a very adversarial procedure, arbitration. You've got a public hearing, which is unusual for arbitration. You may have the need for cross-examination. It's all difficult to see how it stacks up and sits together, isn't it?
Definitely taking lots of different ideas from different methods of dispute resolution and putting them all together. I'm going to be interested to see how it all hangs together.
And there's no cost shifting jurisdiction either, is there? I think, am I right in saying that the person who applies for arbitration has to pay the arbitrator's fees initially, and that those fees can be otherwise dealt with in the arbitration award. But if either party uses a lawyer, they can't claim their costs of doing so from the other side. I
think that's right. There's an express provision saying lawyers' fees, everyone each has to bear their own. And there's, interestingly, I mean, there are other jurisdictions where there's a limited sort of ability to cost shift, but there's often a provision saying the tribunal can make a different provision in the case of a party's unreasonable behaviour. There's none of that here. There's nothing. I mean, and given the value of some of these claims.
And also the fact that this is the tail end. These are parties that haven't been able to reach a resolution for years. They're going to be the most intractable and difficult disputes, probably, aren't they? With lots of scope for unreasonable behaviour. So very interesting. There's an awful lot to talk about. And our colleagues, Jessica Brooke and Sri Carmichael, are going to be dealing with the insolvency aspects of the draft legislation. But I think watch this space. There's so much to be discussed, isn't there?
Lots of interesting things to come.
Thank you.